Okay, I'm reading from the California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparative Analysis in Chapter 7, Default Judgments, Part 5, Relief from Default Judgments, Relief sought within 6 months, from Beeman v. Burling, the Court of Appeal of California First Appellate District of 1990, Klein is the presiding justice giving the opinion that Appellant Spencer M. Burling appeals a default judgment rendered against him in the amount of $197,044.01. He asserts the court abused its discretion in denying relief from default under Code of Civil Procedure Section 473. We affirm, which means they disagree with the appellant. Okay, the background is that the appellant purchased an apartment building at 76 Deming Street in March of 1986. On approximately March 24th, he served an eviction notice upon respondent John Beeman, indicating he wished to occupy a residence unit himself. Respondent moved out of the apartment on April 1. Respondent testified that although appellant did move into the vacated apartment, he lived there for less than 3 months. The San Francisco rent ordinance requires an owner to reside for 12 months in an apartment that has been vacated pursuant to an owner move-in eviction notice. On May 20th, 1986, appellant served an eviction notice upon another tenant, Richard Cronstedt. Mr. Cronstedt testified that the notice indicated the appellant's business partner was intending to occupy that unit. He vacated the apartment approximately June 12, 1986. Similarly, in June 1986, another tenant, Steve Munnell, received an owner move-in eviction notice from appellant's business partners, Emmett Hayes and Robert Hill. On August 20, 1986, respondent sued appellant for wrongful eviction. Following appellant's motion to strike, respondent filed a first amended complaint. The amended complaint alleged that appellant had wrongfully evicted respondent with the intention of renting the vacated unit at a higher rental rate and thus increase the building's overall value. The complaint set forth 14 causes of action, including actions for negligence, constructive eviction, fraud, and violation of rent ordinance. Respondent sought special and general damages according to proof, punitive damages, and treble statutory damages under the rent ordinance. Appellant demurred and moved to strike portions of the amended complaint. Following a hearing on January 20th, 1987, the court overruled the demur, granted the motion to strike in part, and ordered appellant to respond to the complaint within 30 days. 4 other tenants of 76 Deming Street also filed suit against appellant, alleging similar causes of action. All were represented by the attorney representing respondent. Counsel eventually agreed that appellant would respond to all of these complaints on or before May 16th of 1987. Timely answers were filed in 3 of the pending cases. On May 22nd, respondent's counsel served appellant's counsel, Mr. Zimmerman, with statements of damages in the instant case and in the case filed by another tenant, Richard Cronstedt. Appellant also offered, pursuant to CCP Section 998, to settle the matter for $30,000. On June 19th, respondent's counsel wrote to Zimmerman warning that he would take appellant's default in Cronstedt and Beeman cases if no response was filed. By June 27th, no answers were filed. Appellant counsel did not respond to the default warning because he was distracted by the hospitalization of his girlfriend on June 20th. During the hospitalization, his girlfriend's young daughter was left in the care of her grandfather, who was mentally impaired, and counsel was required to assume significant responsibility for the care of the child. According to Zimmerman's declaration, during this time, he believed an answer had been properly filed in this matter. He did not notice any letters threatening a default until he received a request to enter default on July 1 of 1987. Respondent's counsel refused to have the default set aside, stating his client would not permit him to do so. However, counsel did grant appellate looks like he grants appellate's attorney an extension to respond to the Cronstedt matter. By his own admission, Zimmerman simply blocked the case out of his mind and did not file a motion to have the default set aside. A hearing on the default judgment was held on October 21, 1987. Respondent and 3 other tenants testified regarding the eviction notices they received when they lived at 76 Deming Street. Stephen Munnell asserted that appellant was unpleasant and threatening and did everything to make his tenants feel completely uneasy. Richard Cronstedt described appellant's intimidating manner and stated he was very rude and very abrupt. Maurice Jarrett also complained that he felt threatened by appellant and was intimidated by appellant, yelling at the tenants that they were to get out or else. The witnesses also testified that following respondent's eviction, appellant did not occupy respondent's apartment for a continuous 12-month period, a fact which under the rent ordinance raises a presumption that the eviction was not a valid owner-occupied eviction. Based on this evidence, the court awarded respondent $197,044.01 damages, costs, and disbursements. Appellant was unaware of these proceedings and did not learn of the judgment until he retained new counsel on November 2, 1987. His new counsel moved for relief from default on the grounds that 1. The default was taken in violation of the Code of Civil Procedure, Section 425.11, which he alleges has been construed to require personal service of a statement of damages, and 2. An answer was not filed due to his former counsel's excusable mistake and neglect, which warrants the granting of relief from default under CCP Section 473. The court denied the motion on the ground that appellant had not demonstrated the default resulted from counsel's excusable neglect. Appellant moved for reconsideration of the motion to vacate the default. Respondent objected, arguing the motion was untimely and did not allege any new facts. The court denied the motion because no new facts were alleged and the record was inadequate to establish abandonment. This timely appeal followed. So here's the discussion after the procedural. History's been sort of taken out. We've got procedural irregularity section A, and then we skip to D, denial of motion for relief from default. On January 13, 1988, a hearing was held on appellant's motion for relief from default under CCP Section 473. At that time, the court heard arguments from counsel and denied the motion, concluding appellant had not made the requisite showing of excusable neglect. Appellant now asserts this was error. It is axiomatic that a motion for relief from default under Section 473 is addressed to the sound discretion of the trial court. The exercise of that discretion will not be disturbed on appeal, absent a clear showing of abuse. And cites Martin v. Johnson of 1979. Quoting, a party who seeks relief under Section 473 on the basis of mistake or inadvertence of counsel must demonstrate that such mistake, inadvertence, or general neglect was excusable because the negligence of the attorney is imputed to his client and may not be offered by the latter as a basis for relief. The client's redress for inexcusable neglect by counsel is, of course, an action for malpractice. Citing Carroll v. Abbott Laboratories of 1982, in the instant case, appellant's counsel was warned on June 19th of 1987 that a default will be taken on June 27th. The default was, in fact, entered on July 1, although appellant's counsel was informed that a prove-up hearing would be scheduled for October and was called by opposing counsel in September to ascertain whether he would be bringing a Code of Civil Procedure Section 473 motion prior to the hearing. appellant's counsel did not take any steps to have the default set aside. While appellant contends that his counsel's girlfriend's hospitalization led to the default, that does not explain why counsel failed to respond to the first amended complaint from February through June. Moreover, since counsel's friend was only hospitalized from June 20 to June 24, and was then released without restriction, it is not apparent why counsel was unable to respond between June 24th and July 1, when the default was entered. Finally, there is no reason offered for counsel's failure to promptly seek relief from default once he returned to his business and realized his error. Excusable neglect is an act or omission which might have been committed by a reasonably prudent person under the same circumstance. From Transit Ads Inc. vs. Tanner Motor Livery of New York. In the absence of any reasonable explanation for the attorney's errors, the court was entirely justified in finding the neglect inexcusable and denying appellant's request to be relieved of the default. Finally, appellant argues that he was abandoned by his attorney and should therefore not be charged with or penalized for counsel's errors. The support of this claim, he cites Daly v. County of Butte, 1964, where the court found the plaintiff's attorneys guilty of gross misconduct, which resulted in dismissal of the action due to lack of prosecution. Plaintiff moved for relief from default, which was denied. On appeal, the court observed that attorneys had never personally appeared on any motion or in any pretrial conference and had never communicated on any motion or in any pretrial conference and had never communicated with the court concerning any of the calendar hearings or pretrial conferences pertaining to the case. The attorneys also held plaintiffs requested substitution of attorneys for over 5 months without acting on it until the defendant moved for dismissal. Under these circumstances, the court held the plaintiff had been deprived of effective representation and would not be charged with the misconduct of her nominal counsel of record. Accordingly, the court reversed the trial court's denial of plaintiff's motion under CCP Section 473. Daly is an opposite. Here, unlike counsel in Daly, Attorney Zimmerman continued to act, albeit ineffectively, as appellant's representative. For example, when Zimmerman finally realized on June 27th that a default was imminent, he phoned respondent's attorney and asked to have appellant relieved of the default. Soon thereafter, respondent's attorney spoke with Zimmerman concerning settlement of the case. When respondent's counsel met Zimmerman in late August or September of 1987, he said he intended to bring a motion for relief under Code of Civil Procedure, Section 473. On September 24, Zimmerman repeated this intention to respondent's attorney. During a telephone conversation at the Section 473 hearing, appellant's new counsel explicitly admitted there was ongoing settlement negotiations between Zimmerman and respondent's counsel after the July 1 default. Alright, so in Carroll v. Abbott, here at the top of page 154, our Supreme Court reviewed Daly and concluded that the Daly exception should be narrowly applied, lest negligent attorneys find that the simplest way to gain the twin goals of rescuing clients from defaults and themselves from malpractice liability is to rise to ever greater heights of incompetence and professional responsibility. With this guideline in mind, we cannot say that the court erred in concluding appellant had not been abandoned within the meaning of Daly v. County of Butte. At oral argument, appellant's counsel informed the court that opposing counsel that an amendment to Code of Civil Procedure Section 473 that became effective after the completion and briefing of this case made relief from default mandatory whenever the attorney attests that his mistake, inadvertent surprise, or neglect resulted in the default at issue. She argued that because appellant's trial counsel had sworn that the default resulted from his neglect, the appellant was entitled to the benefit of the amendment. In 1988, The Code of Civil Procedure, Section 473, was amended to provide that, notwithstanding any other requirements of this section, the court shall, whenever an application for relief is timely, in proper form, and accompanied by an attorney's sworn affidavit attesting to his or her mistake, inadvertent, surprise, or neglect, vacate any resulting default judgment entered against his or her client unless the court finds that the default was not in fact caused by the attorney's mistake, inadvertent, surprise, or neglect. The court shall, whenever relief is granted based on the attorney's affidavit or fault, direct the attorney to pay reasonable compensatory legal fees and costs to opposing counsel and parties. This amendment became effective January 1 of 1989. The amendment changes the prior statute in two significant ways. While the pre-amendment statute provided that a court may relieve a party or his legal representative from a judgment taken through mistake, inadvertent, surprise, or excusable neglect, the amendment states that the court shall vacate any judgment resulting from the attorney's mistake, inadvertent, surprise, or neglect. Thus, while the prior law was discretionary, the amendment is couched in mandatory terms, whereas the prior statute only recognized excusable neglect. The amendment provides relief for defaults found on an attorney's neglect, regardless whether it may be characterized as excusable. Appellant asserts that, pursuant to this amendment, relief from default must be granted unless the court finds the default did not, in fact, result from an attorney's mistake, inadvertent, surprise, or neglect. The legislative history of the amendment supports that position. Respondent does not offer a contrary interpretation, but only argues the amendment ought not be applied retroactively to relieve appellant's default. CCP Section 3 states that no part of the code is to be applied retroactively unless expressly so declared. Appellant acknowledges this principle and admits there is no legislative indication that the amendment to Code of Civil Procedure Section 473 was intended to apply retroactively. He nonetheless argues that the statute may be applied to this matter without violating Section 3 because the amendment affects the procedural rather than substantive charges. Appellant's position, which rests on the assumption that procedural rules such as CCP Section 473 are retroactive, is overly simplistic and begs the key question over whether past events will be affected by retroactive application of the amendment. If the amendment version of Section 473 were applied retroactively in this case, appellant would have an opportunity to go forward and defend the case on merits, despite the fact that under the law existing at the time of the default judgment, he clearly lost that right. As such, the retroactive application of this amendment would substantially affect substantive rights under Aetna Casualty and Surety Co. vs. ind.acc.com of 1947 and its progeny. This is impermissible. Accordingly, the amended version of the Code of Civil Procedure Section 473 cannot be applied retroactively to provide appellant relief from default. The judgment is affirmed. The cause is remanded to the trial court for a determination of the appropriate award of attorney's fees and costs to respondent. Which is a shame because it's not really retroactive when the case is still open on appeal. But we didn't get there. We didn't get to that question / issue. Notes and questions regarding the relief from default judgments, like the case notes. One, mandatory relief and accompanied by attorney's affidavit and neglect. An amendment to the CCP 473 of 1988 greatly broadened the grounds for relief from default to now include attorney mistake and neglect, even when the neglect is inexcusable. If the application is accompanied by the attorney's sworn affidavit attesting to his or her mistake and neglect, the court must vacate the judgment default or default judgments. See Metropolitan Services Corp. versus Casa de Palms. Alright, how many more case notes do we have? We have quite a bit. We have at least 2 more pages of case notes, which is 2.5 more than I feel like reading. But default judgments are actually not very well laid out in statute, so maybe this will clarify. Mandatory relief provisions in 473 require the trial court to grant relief in if the attorney admits neglect, even inexcusable neglect, within a 6-month period. Section 473 Attorney's affidavit provision mandates relief unless the court finds that the default is not in fact caused by the attorney's neglect. This provision requires a trial court to assess both credibility and causation in determining whether the default was due to attorney error. See Stafford v. Mack. Any mistake that may have contributed to the entry of default was the fault of the insurer and not any attorney, and therefore the mandatory provisions of Section 473 were inapplicable. Marriage v. Hawk and Gordon-Hawk of 2000. Attorney negligence does not need to be the exclusive or sole cause of the client's loss for 473's mandatory provisions to apply if it was, in fact, the proximate cause of the default. B. What incentives are there for an attorney to prepare and file an affidavit of neglect in support of 473 motion to set aside a default? If the attorney refuses to sign an affidavit of neglect, what must the defaulting party prove in order to convince the court in its discretion to grant relief from a default under 473? What are the policy reasons behind the different treatment afforded defaulting parties under 473 in cases where the request for relief is accompanied by an attorney's affidavit of neglect, as opposed to those cases where no such affidavit is available? Is the difference in treatment wise policy, and why? Discretionary relief for excusable neglect or mistake. In cases such as Beeman, where no affidavit of attorney's fault is filed, the courts often decide a 473 motion by determining whether the default was due to excusable as opposed to inexcusable mistake or neglect by the defendant or the defendant's attorney. To determine whether a mistake was excusable, the court inquires whether a reasonably prudent person under the same or similar circumstances might have made the same error. From Zamara v. Claiborne Contracting Group, Inc. The general policy under 473 is to have every case tried on its merits, and that policy views with disfavor a party who, regardless of the merits, attempts to take advantage of the mistake, inadvertence, or neglect of his adversary. See Corey, Crew, and Yeager v. Sebeck, Inc. of 1990. Unless inexcusable neglect is clear, the policy favoring trial on the merits prevails, and doubts should be resolved in favor of the request for relief from default from Elston v. City of Turlock. A. Even though the policy of the law favors trial on the merits, Beeman illustrates some showing of excusable neglect or mistake and of meritorious defense is necessary to set aside a default judgment under Section 473. For example, relief from default has been denied for failure to show excusable neglect where the defendant corporation incorrectly believed service of the complaint and summons was defective, but offered no other excuse for failure to timely respond by motion to quash or by answer. Corey, Crew, and Yeager v. Sebeck, Inc., where the party or his attorney deliberately refused to take action timely and adequate steps to avoid default. Example, Elms v. Elms of 1948. B. The courts have also found inexcusable neglect and mistake in cases where the general press of business prevented the defendant's attorney from filing a timely response. From Elston v. City of Turlock. Press of business absent unusual circumstances insufficient to warrant relief from default. But see Robinson v. Variella of 1977, excusable neglect found where default causes by press of business at defense counsel's office due to illness of chief trial attorney, limited office hours during a holiday week, preoccupation with other litigation matters, short time in which to answer, and plaintiff's quiet taking of default. C. In light of these examples, do you agree with the Beeman Court's finding of inexcusable neglect, and why? Inexcusable neglect of attorney not imputed to client when positive misconduct. I really don't disagree, because I had a chance to correct course, and there really was no excuse or affidavit for excuse for that second failure to act. 3. Inexcusable neglect of attorney not imputed to client when positive misconduct. The inexcusable neglect for attorney is imputed to the client and is not grounds for 473 relief in the absence of the attorney's affidavit of fault. Carroll v. Abbott Laboratories, 1982. As Beeman suggests, however, when the attorney's neglect is such an extreme degree that it amounts to positive misconduct, an abandonment by the lawyer of his client, and a de facto severance of the attorney-client relationship, the client should not be charged with the attorney's negligence. We're also getting a Daly v. County of Butt citation there. What are the policy reasons for this positive misconduct rule? Is the distinction between attorney positive misconduct grounds for relief from default and attorney inexcusable neglect not grounds for relief from default a reasonable one, a workable one, a fair one? Do you agree with the Beeman Court's finding of inexcusable neglect and no positive misconduct by the defendant's attorney, and why? Does this rule encourage negligent attorneys to totally abandon their clients in order to rescue their clients from defaults and themselves from malpractice? Kind of. But if someone's literally that bad of an attorney, I think they don't know about this case. But I, even in my first 6 months of practicing, am very familiar with this part of the code. So, anyway, despite the Carroll Court's attempt to limit this abandonment rule, does this rule still benefit parties who choose the most negligent attorneys? For criticism of the Carroll Court's restriction of the positive misconduct rule, blah blah. Okay. Go see secondary source information. Positive misconduct excusing an attorney's inexcusable neglect. 4. Relief sought after 6 months. After the 6-month period has passed, relief from default is no longer available based on statutory grounds of CCP 473, independent of the statutory authority. However, a court has inherent equity power to grant relief from default judgment where there has been extrinsic fraud or mistake. From the Rappelia v. Campbell case of 1994 and Marriage of Park in 1980. A. Extrinsic fraud or mistake. Extrinsic fraud or mistake is a broad concept that tends to encompass almost any set of extrinsic circumstances which deprive a party of a fair adversary hearing. Marriage of Modnick in 1983. The particular circumstances need not qualify as fraudulent or mistaken in the strict legal sense. The clearest examples of extrinsic fraud are in cases where the aggrieved party is kept in ignorance or is in ignorance of the proceeding or is in some other way induced not to appear. State of Sanders of 1985. The equity power to grant relief from a default based on extrinsic fraud or mistake is similar to the statutory power to vacate for excusable fraud or neglect under CCP Section 473, although the equity power is usually considered narrower. See example, Carroll v. Abbott Laboratories, Inc. and Rappiella v. Campbell, Supra. B. Intrinsic fraud and mistake. By contrast, intrinsic fraud or mistake exists where a party has been given notice by an action and has not been prevented from participating therein, but unreasonably neglected to do so. A party has been given notice of the action and has not been prevented from participating therein, but unreasonably neglected to do so. Kolchar v. Kolchar, Marriage of 7 Knot. This is 1969, 1984. A party's mistake as the law or the facts is usually an insufficient basis to set aside a default judgment if the party could have reasonably discovered the mistake. in 7 Not Supra Hyman vs. Franchise Mortgage Acceptance Corp. Of 2003. Although value of company was the very subject of the lawsuit, defendants' alleged misrepresentations about company's financial condition were intrinsic, where plaintiff conducted no investigation or discovery into the financial condition. Home Insurance vs. Zurich Insurance Co. Of what date and time? 2002. Misrepresentation by insurer's attorney that policy limits are $15,000 instead of $500,000, which induced injured party to settle underlying suit for $15,000 after conducting no discovery, held intrinsic because a reasonable investigation and use of discovery would have disclosed the true extent of insurance coverage. There's just going to be C, D, and 5 left in this recording. So C, viability of the extrinsic-intrinsic distinction. The courts have criticized the distinction between extrinsic and intrinsic fraud as quite nebulous and hopelessly blurred. C, marriage of Steve Knott, marriage of Baltons. That was in 1989. The restatement second of judgments of 1982 does not distinguish between extrinsic and intrinsic, nor does Rule 60B of the Rules of Civil Procedure, Federal Rules of Civil Procedure, that is, which expressly abandon the distinction. D, policy reasons. What are the policy reasons for the California's extrinsic-intrinsic fraud distinction? Is this a reasonable distinction, a workable one? Are the difficulties in applying this extrinsic-intrinsic fraud distinction less evident in cases where a party seeks relief from a default judgment as opposed to a judgment after an adversarial hearing? Why should the court simply ignore this distinction when considering requests for relief from default judgments, but apply it to requests for relief from other judgments? And last 5, void judgments. A default judgment can be void for lack of personal or subject matter jurisdiction, Ford vs. Hyde, or from 1866, or for the granting of relief, which the trial court had no power to grant, Becker vs. SPV Construction Co. of 1980. A trial court has the inherent power to set aside a judgment void on its face at any time, Reed vs. Balter of 1993, Stevenson vs. Turner of 1979. A default judgment in excess of the amount stated in the complaint or a statement of damages, for example, can be collaterally attacked after the 6-month period has expired, Becker vs. SPV Construction Co. Supra, and may even be challenged for the first time on appeal, National Diversified Services vs. Bernstein of 1985, and Petty vs. Manpower Inc. of 1979. So the next part of Chapter 7 is going to be about involuntary dismissals that we'll catch in another recording.